Hi, welcome to class. I'm Elaine Engelhardt from Utah Valley State, and the class is Ethics and Values. Today, we're starting our segment on sexual morality, and the topic is quite explicit, so I'd like to give you parents a warning that this may not be appropriate for children under 18 years of age, and that if your children under 18 are watching this with you, that would be fine. Otherwise, I wouldn't suggest that they watch this program alone. And also want you to know that the views expressed in these programs are not necessarily those of myself or my guests who are here, or that of Utah Valley State College. Maybe, maybe not. And we just try to give a very open view. My guest for today is Matt Nagel. Thanks for joining us today, Matt.
Thanks for having me.
Matt's one of our adjunct professors with Utah Valley State. And over here we have Lloyd and John.
Glad to be here.
Thank you. Glad you are here. And Kisper and Aaron. And Matt, you want to tell us just a little bit about yourself?
I would love to. On the topic of the day, Roe versus Wade, I have 3 children. I have a 4-year-old boy, a 3-year-old boy, and a 3-month-old boy. And I'm building a house in Oakley. And I actually grew up in New Orleans, and my academic training is primarily at Vanderbilt University in theology.
Well, today we're going to be talking about a really difficult subject, the difficult subject of an unwanted pregnancy. I think for most people, most couples, when they find out they're pregnant, they are really excited. We have celebrations, we go out to dinner, probably in your family setting. It was an exciting time. Do you want to tell us a little bit about it?
I don't remember which of the children it was, but for Valentine's Day, my wife gave me the little EPT thing in a box all wrapped up, and that was my gift. So, and it was happy.
Cute.
We were very excited. So.
Yeah, that is cute.
Yeah.
And then we have the very difficult situations where it's an unwanted pregnancy, and the celebrations really aren't there. Or it's a real terrific adjustment as the woman and sometimes the woman and man decide what will happen with this unwanted pregnancy.
Anxiety instead of joy.
Yeah, anxiety instead of joy. So, Kisper, tell us about your excitement when you found out you were expecting.
Well, we were very excited. I'm 4.5 months along, and we're thrilled.
Oh, that's wonderful. And how about your reactions? Anything, Aaron? With
when I had my daughter, who is now 10, just turned 10, we were very excited, and my immediate family and my extended family was very involved. But I had been pregnant once before and miscarried, and it was an unwanted pregnancy. And that was a very different situation.
Very different. So an unwanted pregnancy is very different.
Very.
Okay, so when we look at an unwanted pregnancy, then we think about, well, then what are the ways that we get around having an unwanted pregnancy? And Lloyd and John, do you want to tell us a little bit about this? How did your folks approach the subject of an unwanted pregnancy? Lloyd.
My parents basically said, "Lloyd, you weren't wanted." That's good. No, this conversation actually never happened with my parents. My dad tried to talk to me once. I think we were camping one time and we were sitting down at the campfire, and my dad said something, and I wasn't sure. I don't remember what he said, but I knew where I was headed. And I just told him, "No, Dad." He's like, "No." He's like, "Okay, that's fine."
I'll find a book. How about with you, John?
I was raised in a situation where abortion was not an option, and if you happened to get your girlfriend pregnant, then adoption was the best option, and there was really no discussion beyond that, really.
Okay.
So.
All right, thank you. I remember when I very first started teaching this Ethics and Values course back in 1986, and it was a very uncomfortable subject for me to teach. And so I visited with some women at the reproductive clinic where they did all kinds of reproduction, whether it was helping infertile couples, whether it was doing abortions, or even delivering children. And visited with them about how they teach sexuality. And as they were telling me about the women who come in for abortions with the unwanted pregnancy, the wide variety that there are, how many were so very young, how many others were on welfare and already had numerous children and just had no husband and couldn't face the prospect of another. And it helped me to understand, but it also helped me to sit down with my children. And I brought home the very charts that they were using at the clinic. And my children were still quite young, first grade and third grade, but I showed them the diagrams, the pictures. This is exactly how you get pregnant. If you have unprotected sexual intercourse, there is always a chance that you will get pregnant. So from then on, it was a very open discussion, probably a yearly discussion that I had with the children, and that my husband would often join in as well. How was it at your place, Erin?
My family was fairly religious, but my parents were very open, particularly my mother. I grew up in a family with all girls. I have only sisters. So we just brought our questions to the table, and there was always already a built-in group to discuss it with. Our ages were very close, so often it was a discussion for everyone.
Okay.
That pretty much was it.
Okay, thank you. And so in the state of Utah, it actually is not legal to talk about sexuality or forms of birth control for high school or junior high or grade school students. This is something that is expected to take place in the home, just like it did in yours. And Lloyd, you fail. You were supposed to listen.
Well, they can do it in the schools. They just have to have parental consent.
That's right. That's right. If there's parental consent and it's the appropriate class, then it can take place in the schools. Thank you for that clarification, because I did sign off on those for my children as well. So Kisper, we have an unwanted pregnancy. What are ways of preventing then the unwanted pregnancy? The first one could be, teaching sexuality to your children. What are some other ways?
That's an important one. And then there's obviously birth control. But once it happens, once you have the unwanted pregnancy, your options are fairly few. You can either keep the child, you can have an abortion, or you can give it up for adoption. Those are pretty much your only choices.
Sure. You can keep the child, and perhaps if you're not married, get married, and give it up for adoption, or have an abortion. And I don't like using this word, but I think any of those choices are hell then for the woman who has to face these. It is a very unpleasant prospect. Anything that any of you would like to add to the discussion at this point as far as preventing unwanted pregnancy? I think, John, that you said abstinence is one way of doing it.
One way.
Okay. And since you're married, then you probably use other methods, whatever they may. I'm not going to get personal with you. I'm sorry.
I'm not married. But yeah, birth control happens. I mean, probably the best way to prevent it.
Okay.
So.
All right.
Can I interject something?
Please, Matt, you're our guest.
You raise an important issue, and that is the circumstances in which an unwanted conception occurs. It's one thing if it's unwanted because it's, you're a married and well-to-do socialite, and it's inconvenient because the ski season isn't over. It's another thing if you're a 15-year-old girl without a husband and without, at that, nervous about your future, without the conditions to take care of that child. So the unwanted pregnancy is problematic at various, to various degrees, depending on your situation.
Absolutely, and in fact, we see a continuum that relates to this. And the reason why our first class period is on Roe versus Wade is that this is the law of the land and has been since 1972. And so we're looking at Roe versus Wade and what the justices have to say about it. But let's look at why this is this civil war of the country. Because we have two sides which are pro-choice and pro-life. And each one of them, the way I often see it, is have extremes. So you'll have extremes on the pro-choice side and extremes on the pro-life side. An extreme on the pro-choice side might be that you're living in China, you're only allowed one child, and the government says you will pay all these horrendous costs if you have this second child, and so you're basically forced into an abortion. On the other end of the continuum, on your pro-life, there is no reason then for an abortion, no acceptable reason. If it is the life of the mother at stake, we have to weigh which is more important at this time. The mother's lived 21 years or however long, and should we now give this, this child, this fetus, a chance to live as well? So we see these two extremes. Anyone want to tell me a little bit about these two extremes and then how we start moving into middle ground? Lloyd?
Yeah, I think it's interesting because in the battles, I mean, they are a lot of times battles that go on with this. For a lot of times, it's each side is attacking the extreme. And I think if a lot of times if people realize that these are the extremes, that a lot of pro-lifers and a lot of pro-choicers, or at least people who claim to be that, would find that they really have the same views on abortion. But they just, because each side's been painted and shown as these extremes, they don't realize how much their views agree. Like I think most people who actually read Roe versus Wade as will do will find that they agree with it on both ends of the spectrum.
Okay, thank you. And John?
Yeah, I can identify myself as a pro-choicer, and along with that comes a lot of baggage. I mean, people will make assumptions about what my position on abortion is because I'm pro-choice, and that's kind of unfair to do to a person, is to, just because you might identify yourself as something, to give them, to just basically assume what their beliefs are at that point.
Sure. In fact, we were visiting a little bit before class, kind of saying that when someone thinks you're pro-choice, that it means, oh, well, why don't you go out and get pregnant and try an abortion just to have that as one of life's experiences? And certainly that's a horrendous thought, isn't it, John?
It is.
So certainly it's nothing that ridiculous, and that you're also going to say, this is going to be something within reason. So you're going to have your reasons. What are some of the reasons where pro-life people start saying this is going to be okay? What are some of the first ones, Erin?
Well, the mother's health, which you've already pointed out. And I think often we need to discuss the concept of trimesters when we start to talk about this, because the extremes have to do with those concepts of the pregnancy being split into 3 trimesters. And so that the extreme might even be that someone would allow for partial birth abortions or things like this, something that is now illegal in our country. But the extreme on pro-life would be that there's never, at no time is it going to be acceptable for a conception to be aborted. But then you have the mother's health, and of course all this only within the first trimester of a pregnancy. You have mother's health, then we go into issues of rape or incest, and then concepts of the actual fetus being some kind of severely deformed, and these kinds of ideas, and then going into other concepts of conditions in which the pregnancy is being had, either too young or too old, questions of poverty, questions of ability of the mother to care for the child, these kinds of things, in a kind of sliding scale over to the other side.
Yes, and in fact, Matt was mentioning a circumstance that is often a tough one. Do you want to tell us a little bit about that, about birth control failure?
Attempting to plan your pregnancy and failing in the planning, whether a failure of an IUD, a failure of a condom, failure of rhythm, whatever it is, a failure. You make the attempt to plan, and it still results in a pregnancy, and that's causes a difficult situation.
Okay, very good. So once again, a failure of contraception. You're doing everything possible that you can to prevent this unwanted pregnancy, and now you've got one of these very, very difficult choices to make. Will you go ahead and have this child? Will you have the child and give it up for adoption? will you have an abortion? And all of the options are very tough when the circumstances in life are very tough. So, any further thoughts on this?
I've seen the struggle of a few of the people I've known when they've been faced with this decision, and I've seen how it tore at them. It is miserable. It's not a pleasant thing to have to deal with, to make that decision.
Thank you. And even when this decision is made, as you were mentioning, the trimesters at 15 weeks, when it's a severe deformity, so often this is a very much wanted pregnancy. The couple were happy about it, they'd celebrated it, and then they find out that there's a severe deformity, and the best thing to do is just to terminate the pregnancy now. And it's a very, very heart-wrenching, traumatic decision for the partners in this circumstance. So anything else that any of you would like to add about pro-choice, pro-life, the gradations, or anything on preventing unwanted pregnancy?
Well, I wanted to mention something that Erin said. You asked the question about the extremes of a pro-life, and just the language that Erin used about conception and trimester. Mm-hmm. And I wanted to ask the question: what is the belief behind the pro-life, the extreme pro-lifers' decision that conception is the deadline, or the line in the sand where we can't abort beyond that?
From what I understand, it goes back to the 1880s, and could even be Catholic related, where they were doing they loved to do festivals, and they were doing a festival for the Virgin Mary, and thought they would do one on the conception of the Virgin Mary, and it turned out that men were considered as being ensouled at 30 days and women not until 90 days. And they thought, how could we say this about Mary? And so it was decided then that all ensoulment began right at conception. And so this is one explanation for it, that at the very moment that the sperm and egg unite, then this is considered a person. Erin.
I was going to say, in doing some research about Roe v. Wade and in reading this article that we have here, there's the distinction made between conception and, say, the quickening, which is the first feel of movement, which usually happens late in the first trimester, early in the second. Correct me if I'm wrong here. And then also the idea of anything beyond that. And as our science has gotten to a point where we can actually pinpoint conception versus implantation versus quickening versus all these things, we start to get into some more technical definitions. And I think that Elaine's point about ensoulment at conception is where a lot of the extreme pro-lifers are coming from, whereas we've seen these other gradations as well.
Sure. Quickening, maybe at what point would this person be put on a family group sheet? At what point, if let's say there was a spontaneous abortion or a miscarriage, would this still go on the family group sheet?
We don't typically hold funerals for miscarriages.
No, we don't. Quite often it's a very very sad experience, especially when this is a much wanted child, but we don't hold funerals for a miscarriage.
Well, it is very sad to have a miscarriage, but not really comparable to the sadness of an infant that dies,
right,
or a 2-year-old that dies, or even a 3-month-old. So something happens once a child is born, mm-hmm, that makes it a very different, whether we as the family are more attached to the child or something, but there's definitely a distinction between a born child and an unborn child.
Okay, thank you.
And yet attachment to the child based on how long it's been born or doesn't determine when it's considered alive either. I mean, I understand, right, your point, but
yes, mm-hmm,
there's the difference there too.
Okay, very good. Any other distinctions that some of you would like to make before we get started on this? Well, Erin, do you want to tell us a little bit about Roe versus Wade, and maybe even some of the history that was going on prior to Roe versus Wade?
Well, I think it's important to know a little bit of the history about the legalities of abortion here in the United States in order to understand why Roe v. Wade was such a groundbreaking thing. The important thing to reference is that Blackmun, in his writing of the majority of opinion, states that abortion legislation didn't really exist until the 1800s. Actually, it was 1873 with the Comstock Law. The Comstock Law is actually, I mean, if you think of the obscenity law today, that's the Comstock Law. It outlawed essentially anything obscene, lewd, or lascivious, which is such a great word. And that included anything having to do with reproductive health, anything having to do with any kind of contraception, including abortion. You weren't allowed to provide the service or own anything having to do with the means of preventing a pregnancy, or anything describing anything about reproductive health, anything to sell, anything to nothing. Zip.
Okay. And so, Erin, let me just stop you here, and some of the students might have some questions about this as well. And it might have been that perhaps that abortion was seen as a very dangerous thing, and that if a woman had an abortion, that she could very well die because instruments at that time were not clean. There may have been problems with other infections, and penicillin was not around. So we could have had all kinds of difficulties associated with a pregnancy, and perhaps even associated with use of some birth controls.
Well, I mean, there's an example of a carving at Angkor Wat of a woman aborting a pregnancy. It's been around a long time. It's really nothing new. But the idea of doing it in a safe environment was certainly not something that existed.
Okay.
I'm really fascinated by the association of abortion with those other things in the list in the Comstock Law of obscenities and contraception and whatnot. One of the paragraphs in the Roe v. Wade opinion that Blackmun wrote.
You can just tell us which
the page number.
Yeah.
It's on page 69. About the the second full paragraph, I think. Says it has been argued occasionally that these laws were the product of a Victorian social concern to discourage illicit sexual conduct. And it seems like that's true if that's the list of things that the Comstock Law is prohibiting. Blackmun goes on, Texas, however, does not advance this justification in the present case, and it appears that no court or commentator has taken the argument seriously. And I wonder if, I mean, you talk about the abortion debate as being like a civil war, and I wonder if Blackmun doesn't give enough credit to the Victorian social concern that's at play, especially in the United States.
Okay, thank you. What do you think about that, Lloyd? Do you think that he's giving enough credit to that?
I think in a way, I think he's. Well, I can't say he's given enough credit, but I think he's trying not to give credit to it in the sense that he wants to make a strictly rational appeal and not appeal to people's emotions or religious views or anything like that.
Okay, thank you. And John, I think Erin's making a really good point when she says the Comstock Law is our first law. So prior to this, then these issues of sexuality were family concerns. So these were things that the family took care of. And now you have the government coming in, and the government says, we're going to do this. So whether it's for the reasons you talk about, which would be, Victorian sexual norms, or if it's to save the mother's life because these are unsafe methods, we're not sure. Or it can be any of these. Any thoughts on this, John?
Well, I think it's interesting that you would bring that up, because the Comstock laws might be an indication of the fact that Victorian prudery actually did play a strong role in the illegalization of abortion, which is kind of contrary to something else he says in here when he starts talking about how it was a threat to the woman's life. And we're going to get to that. So.
He seems to be trying to shift the discussion away from
what sexual norms should be.
Sexual morality and into a more medical context.
Right, so that's not going to be his argument.
Right.
Right, very good. Erin, anything else you wanted? Oh, well, of course, you're only at the Comstock Law. You do have more to tell us.
Just a little.
100 years later.
No, actually, it's interesting that just 60 years after the Comstock Law, 1936, is when we see them start to repeal parts of the Comstock Law. It didn't take very long at all. And basically, it's the greatest name for a U.S. judicial case ever. It's the United States versus one package of Japanese pessaries. Does anyone know what a pessary is? It's a diaphragm. Oh. So it's the United States against a diaphragm. I just couldn't help but find the humor in that. And basically, it was a diaphragm ordered by Margaret Sanger, the groundbreaking woman who really championed birth control and basically invented the pill and all of these things. And they repealed parts of the Comstock law having to do with birth control and things coming from doctors specifically, because as the judge in this case said, there was an inconsistency with the law, that if women aren't allowed to get rid of an unwanted pregnancy but not allowed to prevent an unwanted pregnancy, that's a serious problem. And so I think that's an interesting first place to start when it comes to Roe v. Wade. We see that they've legislated that women have the ability to prevent pregnancy, even though the pill at that time was not very reliable, even less reliable than it is now, and along with a number of other things. And then we come fast forward quite a bit to 1971, when they first hear the case of Roe v. Wade.
I said 73 when it was decided. I mean 72 when it was decided.
It's actually 73 when it's decided.
And that's a test question, so 73. Listen to me this time. Not when I said 72, because it's actually decided in 73.
Well, what's interesting about that is, often the Supreme Court will hear cases and decide them within the same session, within the same season. But in the case of Roe v. Wade, they actually heard it for the first time in December of 71, heard it again in October of 72, and didn't decide on it, which is still in the same session, but didn't decide on it until, I believe it's January 22nd, 1973. So they thought long and hard regarding this case. And it was the case of a woman in Texas who claimed that she was raped and wanted to abort her pregnancy, and was able to get two female lawyers to take her case to the Texas courts. And that's the Roe and Roe v. Wade.
Thank you.
Interestingly enough, she later recanted that she was raped, and then later changed her entire story and tried to reopen the case to get it redecided to make abortion illegal, using her status as someone involved in the case. She has issues.
She does, and we have had challenges to Roe versus Wade, particularly with Webster. And what we find in this is that the Supreme Court saying basically that they do not want to override for political reasons what another court has done. However, the states do have a lot of freedom in deciding what their laws will be, such as when is abortion considered illegal in a state. And in many states it's considered illegal at 24 weeks. In the state of Utah it's considered illegal at 21 weeks. And so states have latitude there. They have latitude as far as counseling. And in the state of Utah, then, counseling is mandatory, and this is individual counseling. So it's not counseling with the woman and her partner or her parents. They want to talk with her individually. So other things you want to add on that, Erin?
I just thought it was interesting that when they did decide Roe v. Wade, it was a decision of 7-2. There were only 2 dissenters in that, so it was by far a majority, versus something like Webster versus Reproductive Health Services, which was a 5-4 decision, very close, in which they didn't overturn Roe. And then other recent, or relatively recent, historical things such as South Dakota and Mississippi have changed laws regarding abortion, and making it essentially illegal at any point within the pregnancy other than for the mother's health. And it's not that you can't have an abortion to save the mother's health. Rather, if in the process of saving the mother's health, the pregnancy is aborted, that's okay. So there's a very particular phrasing there that's interesting, and the way that Roe v. Wade is being looked at.
Okay, thank you very much. Matt, did you have any comments on this?
Just the context of the case is interesting. Harry Black, it's not Harry, is it? It's
It is.
Ed.
It's Harry.
Harry. Ed.
It's Harry.
Harry Blackmun that wrote the decision was appointed to the Supreme Court by Richard Nixon, and he was initially considered a very conservative judge, voting often with Chief Justice Berger and the Chief Justice that recently died. I can't think of his name now.
Marshall?
No, the other Rehnquist. I saw some stat where they voted together 90% of the time, and yet this is, one of the very unconservative judgments in the history of the Supreme Court. So for him to write this decision is, I don't know if it's ironic or just interesting to see how he shifted, or maybe this is a topic that is not best understood in terms of liberal and conservative, even though it's often a litmus test for either one.
Okay. Thank you very much. Lloyd?
I think something that's important to really point out is the Texas law that was in play at the time, because most pro-lifers I know will say, yeah, abortion's wrong, but you should be able to have it in cases of rape, incest, but it smells good. Incest. And when the life, and they'll also usually say the health of the mother's in danger. But at the Texas law at that time, those were all illegal as well, except when the mother's actual life was threatened. And so, that most pro-lifers would be against, at least most pro-lifers I know would be against that Texas law and the more recent South Dakota and Mississippi laws. And so, in a lot of ways, a lot of pro-lifers would essentially agree with Roe versus Wade on a lot of these aspects.
Okay. Why do you think that the pro-lifers that you know are opposed to, would be opposed to what's happened in South Dakota and Mississippi?
Well, I think because, like I said, because most pro-lifers agree that, especially I think the big ones is rape, where a woman is raped because pregnant like that, she should have the right to be able to abort that child, at least at an early stage. And what's happening with these new laws is that's illegal. And so they either have to go to another state or go back to the old-fashioned and dangerous methods of doing it on their own.
Actually, they can't go to another state, particularly a minor can't go to another state. They've actually passed laws, I believe it was in 2000, it was either in 2004 or 2006, the Child Protection Privacy Act, something strange like that, in which it is illegal, including grandparents, parents, any kind of a relative, to take a minor out of the state for the purpose of getting an abortion, even if the closest clinic just happens to be, if you lived near the state border, kind of an idea. That's also illegal.
And those who are prosecuted begins with the doctor. So the physician in this case is probably not going to take this on. Matt?
Your comments that most pro-lifers today may not be satisfied with the Texas law is just kind of a metaphysical question, is what determines where we draw the line in the sand, and the status quo, whatever the law is currently, so often determines the language that we use to discuss these things. Even if we're not talking specifically about Roe, we talk in terms of trimesters and conception and vitality in 24 weeks. And it's almost like, because this is the law presently, that's what sets the stage for our conversations about it. Before Roe, it may have been a very different, whatever the law was before that, as in Texas, the conversations would be very different, and the line in the sand that we draw would be at a different point.
Okay, very good. Well, Lloyd, let me come back to you and have you just tell us a little bit about Roe versus Wade then.
Well, one of the things they were trying to do with Roe versus Wade is they were trying to make it more objective. They didn't want to appeal to their emotions and feelings, and they didn't want to appeal to different religious beliefs, because people feel differently about this. People have different religious beliefs, and to support one religious belief or another, or to support one person's feelings over another, would be very subjective and hard to justify. So they wanted to make it objective. So one of the first things they did is they went back and they wanted to look at the Constitution, look at different amendments, look at different precedents for the situation. So they went through and looked at like the First Amendment and the Fourth and the Fifth and the Ninth and the 14th Amendments to try to say, okay, what did they say? How did these play a role, and how did these act with this question?
Very good. And from there then we come up with this notion of a woman's right to her own reproductive freedom. And this is found in the middle paragraph on page 70, where Justice Blackmun cites both the 9th and 14th Amendments in saying that it is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Do you want to tell me, though, a little bit about a woman's right to her own reproductive freedom? What if a woman can't conceive, Erin?
Well, I think that's an important question when we start talking about abortion, which is kind of the opposite, or the flip side of that same coin. They're talking about a right to privacy, and that privacy includes a woman's reproductive health. My privacy includes what I do with my body. That could be anything from going to get in vitro artificial insemination if I can't conceive, as well as if I have an unwanted pregnancy, to go as far as getting an abortion.
Okay, very good, thank you. And Kisper, can I have you read the very last paragraph on page 70? It's right at the bottom of the page, first column.
We therefore conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests in regulation.
Okay, so they're going to look then at important state interests in this regulation. Any comments that you have at this point, Matt?
Well, this is an enormous claim that the Blackmun is making in the paragraph we read before, that the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. They find in the 14th and the 9th Amendment the existence of a right to privacy, and there's some precedent for that. But they make this claim that the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. There's very little in the decision to support that statement. He makes this claim, and then paragraphs later, we therefore conclude that the right of personal privacy includes the abortion decision. But I wonder what is his justification for making that claim?
I think one of his justifications might be in the on the next page, middle paragraph, in the paragraph that starts out, all this together with our observation. Can you see where I am, John?
Yes.
Okay. Would you read that?
Yeah. All this together with our observation, supra, that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuades us that the word person, as used in the 14th Amendment, does not include the unborn. Indeed, our decision in United States versus Vuitch inferentially is to the same effect, for we there would not have indulged in statutory interpretation favorable to abortion in specified circumstances if the necessary consequence was the termination of life entitled to 14th Amendment protection.
Okay, so that might clear it up somewhat, Matt. Do you still have questions? So I think that's a very good question that you raise. And is a question often raised?
Well, I mean, I think this is one of the main criticisms of this case, is that they claim that abortion fits under the auspices of a right of privacy with very little justification for it. I think what we have here in this book is not the entire case.
Right.
What follows that paragraph, the one where he first states that it's broad enough to encompass a woman's decision whether or not to terminate pregnancy, is a litany of potential sad consequences of abortion or not abortion, and the argument turns from a rights claim into a conversation about consequences and weighing are these good or bad results of the decision that we're making. And it's just I'm fascinated by this case as a study of reasoning and argument. And I think my feeling is they make a very important claim, and this is really foundational to the decision, but with very little, at least worded, justification for it.
Thank you. And I guess another response to that would be that in revisiting it in the past, that the justices have decided to go ahead and accept the justification.
Sure.
So even though it may be where it's a little thin, they've decided that this will not be a political matter, that one court has decided this and they're going to stay with it then. Any other comments on this, Erin?
Well, I think it's interesting to note that there is no concept literally drawn out within the Constitution of a right to privacy. It's something that has been made possible through amendments and through interpretation, this idea of right to privacy. But to think of not using right to privacy as a legitimate legal concept of our citizenship, I think begins a very interesting discussion. If we start to talk about if we don't have a right to privacy, then all kinds of things become entirely unacceptable. Things that now we find that are essentially legislated against, or that we find supported by the idea of a right to privacy. Abortion just happens to be one of them.
Okay, so things that could really affect men too.
Abortion definitely affects men too, I think.
Absolutely. Okay, well, let's look at our graphics on this and that give us the definitions then that the Supreme Court comes up with. So let's go ahead and pull up the first one, and Kisper, would you read this for us?
Yes. A state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother, without regard to pregnancy stage and without recognition of other interests involved, is violative of the Due Process Clause in the 14th Amendment.
Okay, thank you. So this is where they're going to then, once again, as Matt's pointed out, they're going to base this. He's going to say, he finds the argument pretty thin, but it is upheld. So then we move on in and they say, but we do have some criterion for this, and we're going to divide it up into trimesters. So let's look at the next graphic that talks about the first trimester. And would you read this for us, please, John?
Yes. First trimester. For the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician.
Okay, very good. So basically then what this means, John, is that a woman is entitled to an abortion, a safe abortion, within the first trimester of pregnancy, and that has to be done in a place where a safe abortion can take place. And so they're basically saying before, abortions were not allowed because they were deemed dangerous. Now it is deemed that a woman can die if she has a back alley abortion, which is basically what's happening. The better thing is to have then a responsible physician helping her with this, this termination. Do you want to tell us a little bit more about this, John?
No, I think you got it.
Okay. Any additions to this?
I think it's important that they point out that an abortion within the first trimester can be less risky than the pregnancy itself for many women.
Okay, and from and that's quite a strong medical point of view then, is that an abortion within the first trimester, which is basically up to 12 weeks, is not as violent, not as dangerous as the other options that a woman might have. Lloyd?
I think the important thing is that they're wanting to put they're looking at the woman first. They're saying like this, her health is important, and so they're saying even in the first trimester, it has to be left to the medical judgment of the doctor. You know, if you want to have an abortion, it has to be done. You know, for it to be done legally, it has to be done to through a doctor. You know, so it's not just saying all abortions are legal in the first trimester. It's ones that are performed by a doctor, because if it's you hear it on the news all the time about a girl who gets pregnant and I mean, some terrible things like her boyfriend jumping on her stomach to try to force an abortion and stuff like that, which can be which can risk her life. And so they want to say we want to protect her life, so we still need to put guidelines here.
Okay, very good.
A follow-up to an earlier point that Lloyd made is so now the decision is a medical one. It's not a religious decision. It's not a social decision. It's not a historical or even moral. It's a medical decision now, and that's an important turn from the of the case.
Very good. And any comments on this first trimester then, Matt?
No, I'll pass.
Okay, all right. Well then let's go ahead and pull up the next graphic, which tells us about a second trimester abortion, and this is going to be a more dangerous situation. And would you read this for us, John?
Yes, second trimester. For the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health.
Okay, thank you. And basically what this is saying then is that a woman is entitled to a second trimester abortion, but it must be done in a place that is safe and registered to give a second trimester abortion. So it must be, as we said before, a second trimester abortion, and in the state of Utah this will be up to 21 weeks, is less safe. And so it needs to be done in a hospital or clinic that is licensed to do this by a physician that's licensed to do this. So any comments or questions about this? Erin?
Again, this is part of Roe v. Wade that has been doctored, no pun intended, I guess, due to subsequent rulings, such as Webster and other the ban against partial birth abortion again, so that nationally we have laws against what kinds of second trimester abortions can take place, if at all.
Okay, thank you. But for the most part, then a second trimester in most states is allowed. A woman will not know if she has severe deformities, if she's carrying a child that has severe deformities, till about the 15th week, which is definitely a second trimester abortion. And there can be a variety of considerations, but in Roe versus Wade, she doesn't need to give those considerations, and she is allowed a second trimester abortion. It must be a safe one. So once again, as Matt pointed out, Roe versus Wade is based on medical health and a physician and a woman working together to determine if this is going to be acceptable for her. Any comments on this, Matt?
Our next one is viability, and after we read that, what you just mentioned is going to pose a problem. But should we read viability first?
I think Erin has one comment before we move on.
He's got.
That's what you wanted.
He's on target here.
Okay.
We're segueing in the same place.
Okay. Well then, let's have you read this next one for us, Matt.
Viability. For the stage subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, regulate and even proscribe abortion, except where it is necessary, in appropriate medical judgment for the preservation of the life or health of the mother.
Okay, so Matt, you want to tell us about this then?
Well, one thing that's interesting to note is we've gone from, in the early stages of pregnancies, it's concern for the mother, and now when we get to viability, it's the interest of the state,
okay,
and more towards the interest of the fetus. You say what you were going to say about this.
Okay. Well, it's interesting that in the first and second trimester, we're talking about just the mother here. But then we start talking about the portion that Blackmun says, but we also have the part that Kisper read. But it's not unqualified, and the state does have interests regarding a fetus as a citizen or potential citizen, or however you want to take that. And that they're going to talk about this concept of viability as what determines that. Well, viability is this messy, sticky issue in the sense that as medicine does advance, and because we have turned it into this medical question, this question of viability gets sooner and sooner. I mean, you hear these amazing stories of infants that are born that fit in the palm of your hand, that are a pound, that are in the NICU for weeks upon weeks and months in order to maintain, but they're still considered viable. I mean, that is what they say. Viability includes assistance. So, I mean, 24 weeks anymore is not. I mean, it's still dangerous, but that's certainly not the end.
And
okay.
I think this poses a problem. You've said that the argumentation here has been upheld, and we mentioned near the beginning of the class, largely for political reasons. The courts subsequent to the Roe court have decided not to overturn it for political reasons. This remains the law of the land. But it's scientifically outdated.
Okay, and what happens?
Or medically, I should say.
Sure, and so since it's scientifically outdated, then I guess, Lloyd, what it comes down to is the woman's reproductive freedom. So she is at this stage now where she's, let's say 18 weeks, and comes to her physician and says, I must have an abortion. I must, there's just no question about it. And it's allowed. So it might be that some folks would question this and say, but this infant is viable, but this is now between she and her physician then. Any comments or questions on this? Because now after 21 weeks, then she would not be allowed this abortion.
At least from my understanding, with Roe versus Wade, it gives the state the right to decide, using their own judgment, using their own scientific judgment, whatever, to decide when they want to say viability occurs. And so maybe I'm not quite understanding your question.
No, I think the question is it now medical, or is it, because as Aaron has said, and also Matt, this is a sticky question now.
Well,
We've got a very sticky question. So are we going to go with what science can do now, or are we going to go with the woman saying, this is my reproductive freedom and I cannot have this child and must have an abortion?
Well, I think that's pretty much similar to pretty much every major debate that's gone on in our country, is when does one person's right infringe on another person's right? I mean, that's really, freedom of speech. Almost all these discussions have to do with two opposing rights, and where do you draw the line between the two? And so this one here is the state, is the courts is understanding, look, this fetus, this, whether you want to call it this unborn child or whatever, has certain rights, as, if we want to say it's a person, it has a right to life and whatnot. But at the same time, you have to, so now you have this fuzzy line of when does the women's right over her body infringe upon the right of, if we call it a person, where does that line get drawn?
Very good. And so then we move into this really sticky area that you're talking about. So viability has happened, and in fact, this in the state of Utah now would be at 21 weeks, and a woman comes into her physician and says, I must have an abortion, and now it needs to be absolutely for life-saving reasons. But these are incredibly controversial abortions. As Aaron pointed out, in other states, they've made it so that if the woman's life is in danger, that they must at all means try to save the child as well as the woman. The way that Roe versus Wade is reading here, then, it is still the woman's reproductive freedom and her choice on it.
Or in Lloyd's language, it's the rights of the woman over and above the rights of the fetus or of the state. There's a line on page 71 after Blackmun discusses all the various ideas of how we can define what life is and what life isn't. He says, in view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant women that are at stake. So even when the fetus is viable, it seems like Blackmun favors the rights of the woman over the rights of the unborn child.
Thank you.
I think this brings up an interesting question. If we're saying that Roe v. Wade makes this a medical question to some extent regarding what is available, it is certainly a medical question. It doesn't negate the fact that most people are going to make a decision regarding an unwanted pregnancy, or regarding the fact that they even got into the position to have an unwanted pregnancy, let's be honest, by means of other things. We don't make decisions in a vacuum. I'm not only going to make a decision according to Roe v. Wade. I'm going to take into account the way I feel about my context in my own life. That it may include my religious views, my family, my a whole number of things. And so I think what's interesting about this, and one of the beauties of our Constitution and something like Roe v. Wade, is it's intentionally vague. It's intentionally vague because it gives the states, maintains states' rights, as well as maintains the rights of the woman to make a decision according to her own religious beliefs, according to her own other things, context and situation, but gives her the medical opportunity at the same time. And I think that becomes critical. It's not like this says that everyone has to go out and get an abortion. It just says that if that is something you are comfortable with or you feel is necessary, it is available to you in a medically safe way.
Okay, thank you. Any other thoughts on this, John?
Sorry, that was a bit of a soapbox.
Well, I was just going to mention, I mean, they talk about Texas adopting a theory of life in here, and I think inadvertently Roe v. Wade does also adopts a certain theory of life. I mean, they are supporting the privacy of a woman to a point, and in a way they are at least supporting a theory of life. And I think Aaron makes a strong point here, though, that a lot of the focus of Roe v. Wade is giving the woman the opportunity to have an abortion in medically safe environments. And so they may adopt this theory of life, but in the end it's going to be about medically safe abortions. And yeah.
Okay, all right. Concluding comment on this, Lloyd and Kisper, and then we'll get your concluding comment, Matt.
Okay.
I'll just pass over to Gisper for her.
For
I've
hers
talked enough
first,
today,
and then
so.
we'll come back to you, okay.
Well, I just like about Roe versus Wade that it does put some regulation on it. Because personally, I don't agree with abortion in most cases, but I didn't realize before reading this some of the points that it does make, that it does put regulations on when you can have an abortion and how you can have an abortion. And I like that about Roe versus Wade.
Okay. Any other comments?
I guess
then,
my
Lloyd?
biggest comment is, as I've mentioned before, like with a lot of discussions, I meet people all the time say we need to overturn Roe versus Wade, but they don't. But then they're the same people who says, well, but I think women should have the choice to have an abortion with rape and incest and these other issues, and so they say they want to overturn it, but at the same time they don't realize that it's Roe versus Wade that made those options available for so many women.
Okay, thank you. Thanks. And Matt, your final comment?
In my final thoughts about Roe versus Wade, I think it's fascinating in terms of the arguments that it makes, whether he's appealing to rights theory, it's the mother's right versus the state's right or the fetus's right. That's fascinating. Is it a consequentialist argument? If we make this law, what will happen? Is it a medicine versus morality or religion argument? And all of that is worth studying. It's fascinating historically to see the way the court acted in terms of, legally, in terms of the precedents that it appealed to and the interpretations that it made, and also in terms of the politics involved. And the politics ever since make it fascinating. But ultimately, and Aaron alluded to this earlier, that in our personal decisions of, morally speaking, ethically speaking, should I or should I not have an abortion, I think Roe versus Wade is not a sufficient guide based on the language that it provides us.
Okay, and I appreciate you being here, appreciate the students. We'll continue studying this very tough issue, this issue that has created a civil war in this country on sexual morality, abortion, and other issues associated with it. Bye-bye.